I'll take roll call. Jackie Cooper, absent. Richard Davila,
Present.
Dr. James Fowler, absent. Gary Hahn,
Present.
Jesse Rangel,
Present.
Amy Trost.
Present.
Certify that we have a quorum. Okay, we'll move to item C. The approval of the minutes from meeting January 11, 2017.
Motion to accept the minutes as presented.
Do I hear a second?
Second.
So carried. Okay, we'll move to item D, public comment. Is there any public comment? There's no public comment. Go to item D for staff reports. First report we hear from Executive Office.
Good morning. Mary Winston, Advisory Board Attorney. Our executive staff, which I think we all met at our last meeting in January. Starting in December, we have our Deputy Executive Director, Ms. Carla James, and our Chief of Staff, Mr. Nick Boennis. Brian Francis, our Executive Director, newly appointed last summer. All three of them are busy doing executive stuff and regret that they can't be here. So you're stuck with me. So our report today, session update. TDLR had one of the busiest legislative sessions in this last 85th regular session. Between January and Memorial Day, TDLR staff tracked 341 bills. 130 of those were directly related to our current TDLR programs. 20 dealt with new or transfer programs, and 191 bills that, if enacted, would have affected our agency operations. That could be from licensing to customer service to how we mail out things. Our staff worked as a team, analyzing and monitoring bills, and I always give Jeff Copas a shout out here and embarrass him, but he's fabulous and he keeps us on track. Way from the back, Jeff. Okay, providing feedback as well as resource testimony. TDLR leadership and staff attended 65 hearings before 20 different House and Senate committees. During the past session, there were a few bills that became law and either directly or indirectly affect hearing instrument fitters and dispensers. House Bill 4007 was a cleanup bill. Hearing instrument fitters and dispensers and a number of the other SB 202 transfer programs that came over in the 84th session were part of that bill. Specifically, it removed state residency requirements for advisory board members and clarified some licensing and temporary permit requirements. Senate Bill 1107 related to telehealth and telemedicine. House Bill 490 related to insurance coverage for hearing aids and cochlear implants. And House Bill 1543 provided for client access to their records. All are effective September 1 of this year. So, bill implementation at TDLR has begun. I did make a copy of this for you. You can have one if you'd like. Tamala is handing out the different bills for your reading pleasure. But what I have here is a copy of the health professions bill implementation timeline. This is an internal document. It's available if you want it. We did make a copy just because of all the programs that it entails. It has just several pages, and we didn't want to kill any more trees than we had to. But if you'd like a copy, we'll get it for you. It just entails what this bill team will be doing during this implementation process. We'll develop rules, communicate to stakeholders, appoint and prep advisory boards, hire additional staff, deal with education, exams, IT programs, and more. On our website, tdlr.texas.gov, we have a full review of legislation affecting TDLR programs. On the first page of our website, if you click on the capital picture, It will give you a drop-down of all of our programs and all the bills affecting the programs during this session. You can also follow the agency on our Facebook page or like us on Twitter, and you'll get updates from TDLR. So actually, I've covered the executive office report as well as agenda item G, which talks about the bills that I just briefly went over. HB 4007, Senate Bill 1107, House Bill 490, and House Bill 1543. If you have any questions, I'll be happy to answer them. And that wraps up the executive office report.
Any questions? Okay, we'll move to general counsel office.
Good morning, I'm Wendy Pello, Assistant General Counsel. This is a General Counsel staff report. We wanted to give you an update on a rulemaking petition that the department received regarding Rule 112.2, which is the definitions. In your materials, you have a copy of that rule petition that was filed with the department on June 1st, 2017. We also provided the supporting documentation that we were able to provide you to forward on from that petition and the department's response letter. And just as a reminder, the Administrative Procedure Act sets out the agency rulemaking procedures, and it's one of those provisions that's in that chapter is that it allows a interested person to file a petition with the agency to amend the agency's rules. One of the requirements is that the agency has to act on that rule petition within 60 days. Either we deny the petition in writing specifying the reasons for the denial, or we have to initiate rulemaking, initiate the rulemaking process. The APA also states that the state agencies shall set out the rules for in terms of the form and the procedures for submitting that petition. And so we do have rules under our Chapter 60 rules that provide the details about how someone submits a petition, including submitting the specific language with underlined strike-throughs like that. So we're clear about what they're requesting. The petition on today's agenda suggested adding a definition under Section 112.2 that would define the terminology of all equipment, as that term is used in the licensing renewal rule under 112.32C5. The petition wanted to define all equipment to include test rooms. The General Counsel's Office, we researched this issue. We worked with the Compliance Division staff, who are subject matter experts, and our exec in terms of formulating a response. Based on our research and our analysis, we determined that there was no need for rulemaking to go forward, and that the suggested changes would conflict with the statute. So we've issued a denial letter and denied the petition, and then we set out our specific reasons in that letter. Again, you have copies there. So I'm available to answer any questions or go into more detail if you like. Just want to note that while the department has ruled on this petition, if there are issues that the advisory board sees that are raised in the petition, something you'd want to discuss in more detail, we can put that on the agenda for a future meeting to have a full discussion if there's issues that arose you'd like to discuss, or if there's issues that you'd want to send to a work group. So, any questions?
Any questions? No, ma'am?
Thank you. That concludes our report.
Okay, now we'll move to staff report from Compliance Division.
Good morning, I'm Katie Bryce, and I'll be giving the Compliance Division report. You've been given a paper copy or an electric copy of our report. I would like to point out that I attended the THAA conference last month. It was great to have the opportunity to interact with our licensees. We received a lot of positive feedback and were able to answer a lot of questions. Something else I'd like to point out, which is not on the report, is that the Compliance Health Professions Division has started holding customer service and licensing trainings once a month on the last Thursday of the month. And so we're giving one tomorrow, and it will be totally devoted to the hearing instrument fitter and dispenser program. So we'll be giving a presentation, going over all the different steps for the different permits and licenses, including continuing education provider licenses and course approvals. And we're hoping that by giving these trainings, it'll just improve customer service responses and just help educate everybody. Do you all have any other questions?
Richard Davila, how do you participate? Is it an online participation for the course that you're putting on?
We go down to our office downtown, and people from customer service and licensing come and attend. And then once we're done with the presentation, we put it on our internal internet so people can access the presentation later
Thank you.
and refer to it if they have any questions.
Thank you.
Anything else? Okay, thank you.
Okay, we'll move to E4, staff report, Education and Examination Division.
Presiding Officer Norris, members, everybody, good morning. I'm Fanny Pringle with the Education Examination Division. Before we get started, I wanted to point out that E&E has relocated to here on the North Campus. We had moved from our downtown EOT building, and we are now in the southwest corner of the first floor, room Suite 105W. If you guys want to come by and visit anytime, you're welcome. Division-wide, we continue to make improvements to our hearing instrument program, all our E&E activities and other Phase 1 programs, including procedures, data management, and communications. We are also immersed in Phase 2 development planning and projects, particularly massage, mold, sanitarian, code enforcement examinations, as well as offender education provider program development. We are additionally heavily involved in the agency legislative work groups. I believe we have 8 division members representing on, I think, 8 different work groups, and that's to ensure successful implementation of all the new E&E requirements and program changes coming our way. On the examination side of our division, TDLR has administered our 3rd and 4th practical exams, March 25th and May 20th, and the next practical exam administration will be September 23rd in Austin, Dallas, Houston, and San Antonio. The deadline to register will be September 15th. On the education side of our division, we have continued to do continuing education audits since November 1st, and we are currently working on June and July. We'll be casting audit notifications next week. Lastly, wanted to piggyback on Katie Bryce, E&E staff, Rebecca Armis and myself also attended the THA convention in Houston. We were able to answer questions, pass out candidate information bulletins, and do some recruiting for raters and SMEs. Are there any other questions? Okay, thank you.
Questions? All right, thank you very much. And now we'll go to hear from Enforcement Division.
Good afternoon. My name is John Millick. I'm a prosecutor with the Enforcement Division. Chris Russey, also with the Enforcement Division, is passing out an update to this report. It's actually on the second page. We gave some additional statistics, more up-to-date statistics, but I'll be going over that here in a second. Typically, when I give this report, you'll be hearing about cases that the prosecutor has handled, like myself, that have either resulted in some sort of administrative penalty or some kind of sanction that came as a result of a complaint from a consumer. However, we haven't had a whole lot of those that have gone to that route yet, but we have had some that we have 2 prosecutors that are designated that handle what we call our criminal conviction cases. Those are cases when a licensee either renews or a new person comes into the profession and submits their application. They have to fill out a criminal history questionnaire. We came to y'all with the criminal conviction guidelines that you guys approved and the commission approved as well. And we use those as the roadmap to determine whether or not, if somebody has been convicted of a crime or put in deferred adjudication, that we don't feel that this person is fit for licensure. And if they lie on those applications, or if they picked up a subsequent charge after even being licensed, we can review those and deny either the application or revoke the license. So these three cases are a representation of that kind of a process. So it's not something we will typically see, but it's something I wanted to point out for you. And if you have questions, feel free as we go through this. The first case is a Dennis Gunn. He was a licensed hearing fitter dispenser, and his license was revoked on May 19th of 2017. We got this referral from the Attorney General's Medicaid Fraud Control Unit pursuant to their investigation of Mr. Gunn for overbilling Medicaid. Mr. Gunn subsequently was convicted of aggravated theft in order to pay restitution in the amount of $167,000, $512.91 from the Medicaid funds that he had illegally obtained. The department, upon receiving this referral, opened up a case seeking to revoke Mr. Gunn's license pursuant to that theft conviction. Because it's listed as one of the department's criminal conviction guideline crimes as being directly related to the occupation. Mr. Gunn initially asked for a hearing, but he subsequently decided to sign a settlement agreement, and we got an agreed order basically revoking that license. The second case, John Riley J.R. Ridgway, he was also a licensed hearing instrument fitter and dispenser, and his license was revoked on April 17th of 2017. Again, this case was referred to us by the Attorney General's Medicaid Fraud Control Unit pursuant to their investigation for him overbilling Medicaid funds. He subsequently pled guilty to an aggravated theft and was ordered to pay restitution of $42,950.41. The department, again, opened up the case seeking to revoke his license pursuant, because aggravated theft is, again, a guideline crime, as we call them. We sent all the notice letters to him. He failed to respond, so what the department did is, when we don't have a respondent respond to any of the letters, and if we can prove valid and proper service, we take a default order. It's kind of like an agreed order. It's just one that the executive director signs off on, and at this case, his license was also revoked. The third one is a little bit different in the sense that, as a license holder, if you get convicted of a crime and get sentenced to prison, there's a way to revoke that license by operation of law. That's exactly what happened in Mr. Espinosa's case, is that he sought to renew his an expired license, and while we were what happened is he had a license and it had expired, and he sought to renew that license. But while that license was expired, he had actually gone to prison. And so while researching his criminal history, we determined that he had been in prison due to a felony in 2015. As such, under the Occupations Code 5302B, it provides that license holders shall be revoked on the license holder's imprisonment following a felony conviction, felony community supervision, revocation of parole, or a revocation of a mandatory supervision. Once we found that information out in doing the criminal history review, we sought to revoke that license, and so it is revoked at this time. Going forward, some current projects we're working on, and I will be presenting this later, is that in March 31st, we began the process of developing the enforcement's penalty matrix. And I'll go into further detail later as to what we've come up with. We met on March 31st with the enforcement work group, with Mr. Rangel, Mr. Davila, and Ms. Cooper. And we again met on May 9th to kind of finalize that, and we'll present that later today. If you look at some of the statistics, the first group of statistics was what we presented back in January at that advisory board meeting, and the second set of statistics is kind of through this whole fiscal year all the way up through June of this year. As you can see, between those two time periods, roughly 7 months, we've had an increase of the number of cases, and I think it's just because more people are familiar with the process of filing complaints, where to file them, that, it's now, the hearing fitters program is now over here instead of over at the Department of State Health Services. As you can see, we've opened 45 cases since the program's come over. We resolved 36 of those cases. One of those was an agreed order, and that was that criminal conviction case that I referred to. We haven't yet assessed a penalty or collected one at this point, but that we do still have some cases in the work, and so that report will probably change later. So that's all I've got for right now. Like I said, again, I'll be talking with you about the penalty matrix later, but if you have any questions about this report, I'll be happy to answer them.
Any questions?
Thanks.
Thank you very much. All right, we'll now have a staff report from Licensing Division.
Good morning, Leonard Rivas with the Licensing Division.
Good morning.
Just to give you an update of what licensing is doing, we're not just processing licenses, we're also heavily involved in working on the transition of the programs transferring to TDLR with Phase 2 for the Department of State Health Services that will be transferred on November 1st. We're also heavily involved with the transition of the podiatry board coming to TDLR on September 1st. Those are other things that the licensing division is working on aside from processing applications and renewals. I provided you with my staff report. It's different than typically what you're used to receiving. I'll go over the report with you and then answer any questions if you have any questions. So for the first quarter, that entails the months of October and November. In the second quarter, that would be December through February. And then the third quarter will include March through May. And you can see the number of licenses issued for each of those quarters, the number of renewals, the online percentage, the number of, under the apprentice permit, it says renewal licenses, but those are actually extensions that we issue to those during those quarters. And under the temporary training permit, it's the same as the others. Do you have any questions?
Anyone?
Okay, thank you.
Okay, next on my list, I got item F, update from work groups and possible recommendations, enforcement work group. Has that already been covered? Enforcement?
They're pausing just because there's a Mary Winston TDLR. There's a separate line item, but both items say penalty matrix. So I think they put their heads together and said, yeah, let's go and do that right now. Or report, or what do you want to do? We're at F. I covered G. So H is next, which is penalty matrix. So you can slide right into that if you'd like, John.
We can make it happen. So as I stated earlier, back in March and May, we had a meeting of the advisory work group, enforcement work group, with the sole purpose of creating the enforcement penalty matrix so that the department can recommend that to the commission and publish it. Chris is going to bring up a copy of it, and you should have a copy of it. I don't know if any of the members of the work group want to talk about the process and kind of what they saw from it and kind of the experience they had from it.
Richard Davila. I'll comment that we met on 2 separate occasions via teleconference, and we were able to discuss the severity of, the different violations that were possible. We discussed at length. Goodness, I think the first meeting was an entire morning, at least 4 hours. Where they should be categorized or classified, and those suggestions were then put into a revised document where we met a second time first week in May and revisited the classifications. We actually had a few, after further review, we felt were more critical, less critical. So there was a second revision made and really a final revision. And then in June, we realized that a couple of, that the state legislature had passed some new legislation that really eliminated some of the violations. So the third draft was created, and I think that's the one that we have before us today.
Yeah, that's correct. So basically what I'm going to be doing is that I'll be presenting this penalty matrix to you guys today with the hope that at the end of this proceeding that you would vote to approve this penalty matrix so that we can send it to our commission so that they can adopt it and we can publish it, and then it'll be part of the enforcement penalty matrix as a whole with all of our programs. Before I do, I'd like to generally tell you what the penalty matrix is used for and how we created it. All Chapter 51 agencies are required to set out a penalty matrix, and being a Chapter 51 agency, all of our programs have a similar penalty matrix. It is used to put the industry and the public on notice as to the potential penalties and the license sanctions that are possible if they do violate any of the statutes or rules regarding the hearing instrument fitters program. So that's kind of the public side of things. Within TDLR, the penalty matrix serves as guidance for the prosecutors. So if that we do decide that we need to charge them with a violation, we kind of have a roadmap of how serious something is, what we need to charge, and kind of the range in which we can charge certain violations. Generally, as a rule, the prosecutors are bound by this penalty matrix. So we can't go outside of it. So if something is a Class A, I can't allege that it's Class B. If in the Class A, the range is up to $1,000, I can't charge $2,000. So the prosecutors are bound by what this penalty matrix says. We can go outside of the penalty matrix on rare occasions, but we have to seek the permission of our director, Christina Kaiser, for that, and only on rare and extraordinary circumstances do we even seek that. The penalty matrix is not new law. It does not create new law. It is not a new rule or new statute by any stretch of the imagination. All it does is it seeks to take the statutes and rules that are currently as they are and group them together in ways that the public can understand, sometimes with legalese, takes legalese and puts it into kind of a plain talk version and kind of lets them know, okay, if I don't have a license and I'm found to have committed, practice hearing fitting without a license, this is what I can, probably seek, look to get a violation of. But it also doesn't obligate, just because we have a penalty matrix and have something listed, doesn't obligate us for the prosecutors to charge that. We do have prosecutorial discretion to resolve cases as we see fit because we do have a limited number of resources. So, but it does come into play when we do finally seek to charge somebody in a notice of alleged violation. The majority of our cases are handled informally, either through a written warning, getting the customer put back in a better position, or just finding that there was no violation at all. However, if we do, we follow this penalty matrix. However, the commission is not bound necessarily by the penalty matrix, but they typically follow it. And if we go to SOA and we seek a $2,000 penalty, let's say, and the commission feels that maybe it was a little bit too high, they typically will go on the lower end. They don't usually ever go on the higher end, but they will go on the lower end. But like I said, they're not bound necessarily by it. But they are bound by what the statute is as a $5,000 per violation. They can't go higher than that. So any particular violation, that's the max. And so we created this through the advisory board work group, which was composed of Mr. Davila, Mr. Rangel, and Ms. Cooper. And basically the way we start out any of these penalty matrices is we scour all the statutes and all the rules and put them into a grouping of what we think, at least in the enforcement division, thinks that of what's serious and what's not serious, and where we think things logically flow. Then we bring the advisory board. You guys are the subject matter experts. You deal with this day to day. You know if something's a little bit more serious than not serious. And so that's what we did in this first meeting is we the department put together what we thought the different classification range should be. And then we asked, the work groups like, okay, does this make sense? Should this be in this Section A, or should it be in a Class B? And we had those discussions, and we did move quite a bit of stuff around and move some things up, move some things down, just depending on what you guys see in the industry every day. I want to thank Ron Vosser and Chris Russi for helping with this, along with our director, Christina Kaiser, for kind of spearheading all this. And so after we've decided what classification each of these penalties should be, either Class A. Class A's are the least serious, and the way we have this penalty matrix set out is Class D being the most serious. So once we figured that out, then we worked on figuring out, do we do first violation, second violation. Before House Bill 4007 was passed, there was a statute that said that first violations charged up to $250. Each subsequent violation is $1,000 after that. House Bill 4007 struck that part out, so it made it more in line with the rest of our programs that we have. So we can go up to the $5,000 limit. So with that, we decided that what we should do is just, instead of having the first, second, and third violations, as we do in some of our older programs, Chris can show you what kind of our ACR. This is our ACR program. As you can see, we have first, second, and third violations set out. With all our new health-related programs, we've kind of gone to the thought process of going to a single range. And the reason that we've decided that is because we're not seeing a whole lot of enforcement activity with these programs, so having a second and third violation may not necessarily make sense with these programs. And also, we've noticed that when we have cases that do go before the State Office of Administrative Hearings, we've had some trouble with the judges quite understanding what a second, what a third violation is sometimes, because of just the way sometimes different allegations get pled. And so trying to cut out all that confusion, we figure let's just go with one range, and that gives a prosecutor the ability to weigh factors that might possibly come into play as far as, okay, this guy's been a repeat offender, so I'm going to go up the scale a little bit, versus having to have our hands kind of tied a little bit more so. As such, it's a fluid document, so anytime the legislature meets and changes a statute or rulemaking happens, we can change this document. It's not a static document by any stretch of the imagination. I'm happy to walk through this with you and kind of outline some of the different, where some of the things fall. What we've done is, in all the different classifications, you'll see subject matter headings, like under the first class A, you see administrative violations, posting and public information violations. It's to kind of give you kind of a heads up of like, okay, what are the types of violations that are going to fall under this category. With that also being said, I'll be glad to walk through this with you if you so choose, with the note that because the changes with House Bill 4007 not being effective till September 1, when we get this approved by the commission, if it's before that date, these changes won't take effect until at least September 1, just because that's when that bill becomes effective, and that's when all those things. So any cases that we had open prior to that will fall under the old rule and the old statute, so we'd have to follow what that statute says of the first violation up to $250, and anything subsequent to that being $1,000. So, but with that said, if y'all have any questions, I'll be happy to walk through with you.
I have a question, Jesse Rangel. After September, when these are complete, how hard is it to change a Class A violation to a Class B violation later on?
We just do it at the advisory board meeting. If you guys have seen something being more serious, being more repetitive, that maybe enforcement needs to be stepped up in a certain area, take it to the advisory board and say, hey, I want to look at coming back to the penalty matrix and say maybe we need to move this up, and then it'll go through the same process. If it gets moved up, you guys will approve it to go up to the commission. The commission will review it and hopefully adopt it at that point.
Thank you.
I'm Richard Davila. More of a comment for the rest of the advisory board members. House Bill 4007?
Yes.
Is that what it is? It did repeal a few sections of our statute, and one of them that was removed from our from our penalty matrix was sold a hearing aid by mail and dispensed or fitting hearing instruments on a person who ordered hearing instrument by mail. Couple of things that were removed or will be removed September 1st. I know we've had many a mail order discussions over the years. So I just thought I'd mention that. Those two aren't listed because they were removed by that tweak to the statute.
Any other questions? That's it.
All right.
Thank you.
So at this point, we would just ask for you to approve this matrix to go to the commission at probably the next commission meeting, probably in August sometime, with the hope that they adopt it as well.
Yes, Richard Davila, I'll move to accept the penalty matrix as presented.
Is there a second?
A second?
All in favor?
Aye.
Aye. Any opposed? So carried.
Thank you.
Okay, so we have now went through F and G, correct?
Actually, I reviewed G when I did the executive office report, and Wendy is heading to the table to go forward with I, if that's good with you, Chairman.
It is indeed. So we're now on item I. The discussion of telehealth and telepractice.
Good morning again, Wendy Pello, Assistant General Counsel. This is a discussion that we wanted to bring to your attention with some new issues. This was a discussion that we had with the Speech Language Pathology and Audiology Advisory Board back on June 30th at their meeting. This is an issue that's kind of common to both programs related to telehealth, telepractice. We won't be asking for any action today, but we wanted to just kind of kick this off as a first step in terms of education, what are the issues, and then how this will impact TVLR's rules and future rulemakings. In your materials, we gave you several resources just to kind of bring you up to speed about what's happening. One of those is Senate Bill 1107, which Mary had mentioned in the legislative report. That's related to the telehealth, or telemedicine and telehealth issues. We also provided a bill analysis. You have an updated version, a hard copy in front of your computers that the legislature has available now on the final bill, so a little more updated analysis. We also included in your materials a notice and a statement from the FTC about closing an investigation they had against the Texas Medical Board. And then United States Federal Trade Commission comment that they had made to the Delaware Speech Language Pathology and Audiology and Hearing Aid Dispensers Board regarding some proposed rules they had about telehealth and telepractice. Obviously that issue is very broad, and so but today we're just trying to focus that discussion really on the requirement about having initial contact with a client be in person. And this requirement, it's found in both the speech language pathology and audiology rules, but it's also found in this program's rules as well. For the hearing fitters and dispensers, it's found in your joint rule, and it's joint rule, it's 112.150, the requirements regarding fitting and dispensing hearing aids for by telepractice. And specifically, that section is 112.150L, and that section states a client's initial professional contact with the provider shall be in person at the same physical location. So that's kind of just to put some perspective what the issues we're talking about and what rule we're talking about, is we just kind of want to let you know what's happening on this issue both at the state and the federal level, and kind of have a discussion. There's, again, I said there's no decisions or actions today, to be made today, but we'll be coming back in future meetings with some proposed rules to try and address some of these issues that have been raised in the materials that we've provided with you. Just a little bit more details about what we provided. The information we provided, we take it as, the department takes it as guidance to us. While it may not be specifically directed to TVLR, we take it as guidance of what state agencies and advisory boards should be looking at in terms of these issues, where the trends are going in terms of regulation, where the industry's going as it relates to telemedicine, telehealth, telepractice issues. So in your materials, I said you've got the Senate Bill 1107, and while a majority of that bill really was applying to telemedicine and the Texas Medical Board and some issues that they had been having over a couple of years, There are some issues, provisions related to telehealth, and kind of most notably is it defines what telehealth services is. It has a provision that states that the standard of care for telehealth has to be the same as the standard of care for in-person. You can't have require a higher standard of care for telepractice or telehealth. And also notably is that a state agency with regulatory authority over a health profession or health professional may not adopt rules pertaining to telehealth services that would impose a higher standard of care than the standard of care that would apply for an in-person service. So those are some kind of key takeaways from that, I think, as part of that the legislative process and some of the issues that they were really wanting to address, some of those face-to-face in-person issues in terms of how to create a valid, in that case, valid patient-physician relationship and forming that by telemedicine. Of note that the legislature removed, there was a statutory provision in the Texas Medical Board statute that allowed the medical board to adopt rules to require face-to-face consultation between a patient and physician providing telemedicine services within a certain number of days after having, following an initial telemedicine service. So they had to follow up with an in-person. And the legislature removed that provision and that ability to have rules on that restriction. So I think some important takeaways for us is kind of there's this definitely a move and increased wanting to use and have access to telemedicine, telehealth, telepractice type services, increasing competition, increasing access to care and services. So just be mindful of that as we're moving forward in the rules we do. And again, like I said, while it's primarily directed, that bill is primarily directed to the Texas Medical Board and the issues that they were having, we kind of review that as guidance in terms of just other state agencies, including us, in terms of if you're having telemedicine, telehealth, telepractice type rules, kind of keep these things in mind. One of the other documents we included in your materials is the United States Federal Trade Commission statement regarding them closing an investigation on the Texas Medical Board. Basically, they said with the passage of that bill, Senate Bill 1107, that the FTC had closed their investigation. They had opened up this investigation a while back, and they were investigating the medical board in terms of potentially violating federal antitrust laws by adopting rules that restrict the practice of telemedicine and telehealth in Texas. One thing to make you aware of is the FTC is engaged in terms of looking for anti-competitive behavior, also but consumer protection and finding that balance. One thing they've been looking at for several years now is state boards that are made up of all industry members and concerns that in making sure that those boards, while they can do their license rules, aren't putting in anti-competitive rules to keep out competition. So that's kind of been a focus of theirs. And with FTC and with the telehealth, telepractice rules, they're concerned with making sure there's not any anti-competition or restrictions on access to care and making sure that telemedicine or telehealth or telepractice can be used when it's appropriate and not having rules or statutes in place that create bars to that. The FTC, like I said, has issued a statement. You kind of see kind of what their big concerns are in there. They had praised the fact that the Texas legislature had passed this law and it had kind of removed some of those barriers. So you have that statement in your packet. And then we also included a comment letter that the FTC sent to the Delaware Board of Speech Language Pathologists, Audiologists, and Hearing Aid Dispensers. They said that board is, it's been a couple years, I guess when they first proposed was back in October of 2015. They've kind of gone through the series. I think now they're up to 3. Yes, Jeff.
Richard Davila, if I could make a comment.
Yeah.
For the summary of one of the key points for the FTC statement that was provided to us was making note of the Texas legislature overriding the necessity for the first contact to be face-to-face. Is that right, where they're allowing the first contact to be telemedicine, asynchronous or synchronous, some combination of that? What was removed was the face-to-face initial contact. Is that right?
Yeah, they removed the provision that allowed their medical board to put in rules that would require some type of
Would require that.
face-to-face or require a face-to-face within a certain number of days after a telemedicine. So yeah.
And
it's
that
helpful to-
relationship exists with our rules as well, because
Right.
in our section of the rules, we also require a face-to-face initial
Right.
contact, and that's kind of the tie here.
Right,
Got
and that's
it.
why we're bringing that to your attention,
Got
because
it.
we're seeing, with what's happening with the medical board, we've seen kind of how the FTC weighed in on what the legislature did in response to statute changes with the medical board. We saw that the FTC had opened their own investigation about potential issues with restrictions on telemedicine with the board. And then again, with the comments the FTC sent to the Delaware board in terms of, because the Delaware board, it's like, Texas is not the only state that has these, but was kind of wrestling with these issues of telehealth and telepractice. And the Delaware board had, like I said, it's now gone through 3 kind of versions of proposed rules, and it's kind of evolved from when they started that they were requiring all evaluations, including initial evaluations, be in person. They had public comment, public hearings. They amended that and came back and had it be more restrictive, or less restrictive. They still had it be, initial evaluations had to be in person. And that's the version of the proposed rules that the FTC had commented on. I was saying, you may want to take a look at, is there other ways to do this, that you don't have a blanket restriction to having, prohibiting telepractice or telemedicine for initial contact? Is there a way to balance that, need, because they were saying you're kind of, with a blanket restriction, you're preventing.
Could be.
Could be. And so they were kind of raising these issues, hey, go back. And they weren't saying you can't do this, but they're saying, hey, go back and take a look at, are there other options, other ways of doing this? They had thrown out kind of the American Speech, Hearing, Language Pathology, their kind of association rules, there were models. They had, the Delaware board came back, I guess, a 3rd time, and they had another public comment and rules. But they had removed that provision about initial evaluations being in person, and they'd removed a provision that they eliminated the fact that they had to determine appropriate care only after face-to-face. So you kind of see the Delaware board, how they were evolving kind of through the proposed rule. So like I said, we're kind of bringing this to you today just to kind of, like, this is kind of what's happening in other states, kind of happening at the federal and state level, just as, while it's not directly, addressed at TDLR, it's like we have these types of rules, and we need to be kind of mindful of other ways to make sure we're not having any rules that would be anti-competitive or restricting access to care and services. Is there other ways to do that? So we kind of bring that to your attention right now to have that discussion. One of the things that was flagged in that FTC letter is that Texas was one of 3 states that kind of had that restriction. So that's always, take note of that on that issue. So like I said, we're having this discussion with both advisory boards, because you have common type provisions there. So, if you have any other questions or discussion at this point?
Gary Hahn.
Mhm.
When we went through this with DSHS, one of our questions we had was the qualifications of the facilitators on the other side of the call. Was there any comment in regards to that?
I don't recall that part of it. I can go back and look, but I don't recall that being kind of that piece.
Because one thing we felt like is whoever's putting the hands on the patient should have the qualifications to do so. And this is one thing that we went back and forth on quite a bit. Amy might have some view on that, but so there wasn't any comments as far as the requirements for the facilitators and that?
I don't recall if, I mean, I
Okay.
have to go back and look for that part of it. Yeah, at this point, we were just kind of, this is kind of all that we've gathered, kind of, and then we can kind of dive into those
Right.
type of specific
Right.
issues and on that. And like I said, the FTC had said, hey, you might want to take a look. Are there other ways to do this? It offers some suggestions. So we really want to just have this be kind of an initial kickoff. But yeah, those are good things to kind of dive into.
Okay, so I'm premature on that.
No. You're raising a great issue. That'll be things that we'll want to discuss, but all the issues that.
Richard Davila, about the only thing I recall from reading was that the practitioner be held to the same standard of care as if it were face-to-face.
Mm-hmm.
So same standard of care might rise to the level of licensed professional, somebody capable, as if they were there. That's all. That's my only comment.
Okay. Any other questions or issues?
Any other comment?
All right, well, thank you again. Yeah, we'll come back at a future meeting and have more discussions and propose rule changes, but yeah, we just wanted to kick this off with kind of this is what we're seeing and kind of it's for future.
Richard Davila, could you give me the joint rule section again? It was 112,
Yes.
15, or?
It was 112 points, sorry.
150.
150L.
150L.
Got it.
And it says a client's initial professional contact with a provider shall be in person at the same physical location.
Okay.
All right, thank you very much.
Thank you. All right, we'll move to item J, discussion and appointment of work groups. At this time, the work groups that are in place have been assigned. I have no change
Well,
to
the
propose.
penalty matrix enforcement work group is done for now. With the report that Wendy just gave in the update, and we're looking for a joint rules work group.
Work group, okay. I'm looking to have that appointed today, or you want to put it on the agenda for the,
It is actually, you can make that appointment today.
okay?
And you will be working with speech pathology and audiology together. So we'll probably be remote because we'll have several members from each of the groups. But at your leisure or guidance, we can appoint today. It's your choice.
Okay. How many do you want on it?
We prefer.
Three would be maximum, so.
Do you want to be a part of that, Chairman?
Sure.
And two more from this board, and we will have three from the other board.
Okay.
So we just need you to appoint two more.
Okay. Well, I'll appoint Amy and Gary.
Who was the last one?
Gary?
And staff will be in contact with you concerning a date to set up a meeting.
Okay. Okay, we'll move to item K, recommendations for agenda for next board meeting. Any items?
There may be an update, Mary Winston, TDLR, excuse me, may be an update from this new work group at that time, because we are looking, that session was so darn busy. We are incorporating several new programs into the TDLR family. So we are anticipating this group meeting in January. That will give time for the two different boards to meet and actually have something to present to the full board.
Just a quick question. This is Ben. I haven't said Ben Norris all day, have I? I apologize. Have any progress on the appointment for the public members? Okay.
Again, we solicit, if you all know anyone or anyone out there knows someone who's interested, please apply. The applications are available on our website. Public member cannot be a licensee. We have to have that reminder, but that has been a bit of a difficult one to fill. So we would love to solicit, if you all know someone, we solicit your help.
Do you have any applications in now for that, or applications not approved, or?
Oh, Tamla says we don't have any for that
Have any?
public member
Okay.
position.
All right.
Oh, apparently we are having licensees apply for the public member position, but you can't be a licensee and be a public.
Very good. Okay, item L, discussion of date, time, and location of next board meeting.
According to our bill implementation timeline, the first week in January, actually, we have been stacking meetings as, much as we can. And Tamla has handed me a date of January 10th of 2018. Is everyone available for that date?
Richard Davila, I'm available.
Amy Trost available.
As far as, Gary Hahn, as far as I know, yeah, I'm available.
Jesse Rangel, I'm available.
And this is a couple of days behind the posted time that we have for our own internal schedule. But as we plan all these meetings, and we're kind of getting you in there where we can, so right after the first of the year. So if that's a good availability, Mr. Hahn, good for you as well? Okay. For the 10th? Is 10 o'clock good? Okay. Hard to believe we're already breaking out that 2018 calendar, but we are.
All right, is there any other discussion?
As always, Mary Winston again, if you have other items that you'd like to put on the agenda, email us, call us, let us know.
Okay. We are adjourned.